Hello and welcome to the Minimum Confidence episode for Tuesday, June 17th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, ABA suing Trump, a major DOJ restructuring, the NCAA's $2.8 billion settlement fueling NIL legislation and antitrust reforms, and a model tax amnesty program out of Illinois. Let's remember, the best way to predict your future is to create it, and read today's legal news. On this day in legal history, June 17, 1963, the U.S. Supreme Court decided Abington School District v. Schempp, a landmark case concerning the constitutional boundaries between church and state. The case arose when Edward Schempp, a Unitarian from Pennsylvania, challenged a state law that required public schools to begin each day with Bible readings. The Schempp family argued that this practice violated the Establishment Clause of the First Amendment, which prohibits the government from endorsing or establishing religion. In an 8-1 decision, the court ruled in favor of the Schempps, holding that the mandatory Bible readings were unconstitutional. Justice Tom C. Clark, writing for the majority, emphasized that while the government must remain neutral toward religion, the school's policy amounted to state-sanctioned religious exercise. The ruling did not ban the Bible from public schools altogether, but clarified that its use must be educational, not devotional. This decision built on the precedent set in Engel v. Vitale in 1962, which struck down mandatory prayer in schools and reinforced a broader interpretation of the separation of church and state. The ruling provoked strong reactions across the country, with many viewing it as an attack on traditional religious values, while others saw it as a vital protection of individual liberties in a pluralistic society. The case remains a cornerstone in Establishment Clause jurisprudence, shaping debates over religion in public education for decades. It also marked a pivotal moment in the Warren Court's broader effort to expand civil liberties through constitutional interpretation. The American Bar Association, or ABA for those in the know, has filed a lawsuit against the Trump administration, accusing it of using executive orders to intimidate major law firms based on their past clients and hiring choices. Filed in federal court in Washington, D.C., the lawsuit argues that these actions violate the U.S. Constitution and have created a chilling effect on the legal profession. The ABA claims Trump's actions hindered its ability to secure legal representation, especially in cases opposing the federal government. The suit comes after 4 law firms successfully challenged similar executive orders, with judges temporarily or permanently blocking the enforcement. One of these firms, Sussman Godfrey, is now representing the ABA in this new case. Despite court setbacks, 9 firms have agreed to provide nearly $1 billion in free legal services to the Trump administration to avoid similar targeting. White House spokesperson Harrison Fields dismissed the ABA's lawsuit as, quote, frivolous, asserting presidential authority over security clearances and federal contracting. The ABA also alleges the administration has threatened its accreditation authority and slashed funding, particularly in areas like training legal advocates for domestic violence victims. The U.S. Department of Justice is undergoing a significant restructuring under the Trump administration, marked by mass resignations, staff reductions, and department overhauls. Approximately 4,500 DOJ employees have accepted buyouts through the administration's deferred resignation program, known as Fork in the Road, which allows for paid leave through September before official departure. These exits, along with planned eliminations of 5,000 more positions, are expected to save around $470 million and reduce the DOJ's workforce from roughly 110,000 people. The administration's proposed budget for the next fiscal year aims to reshape the DOJ in line with conservative priorities. This includes dismantling the tax division, once staffed by over 500 people, and distributing its enforcement functions across the civil and criminal divisions. Despite some added funding to these divisions, they are also set to reduce attorney headcounts. The move has drawn backlash from former DOJ and IRS officials who warned it could undermine tax enforcement. The DOJ's top tax official resigned earlier this year in protest. Political leadership changes have also prompted an exodus from the Civil Rights Division, where 2/3 of career attorneys have either resigned or been reassigned. Cuts are also planned for the Environment and Natural Resources Division and other oversight bodies, such as the DOJ Inspector General's Office and the Community Relations Service. Other structural shifts include folding Interpol's U.S. office into the U.S. Marshals Service, closing multiple field offices, and launching a new firearm rights restoration initiative. The administration has also proposed merging the ATF with the DEA and cutting the FBI's budget by over $500 million. The NCAA's $2.8 billion settlement, approved earlier this month, has reignited momentum in Congress for national legislation to address key issues in college athletics, particularly around antitrust liability, name, image, and likeness compensation, and student-athlete classification. Beginning July 1st, colleges can directly pay athletes, marking a historic shift that has intensified calls for a federal framework to standardize these changes. The settlement, which also includes back pay for nearly 400,000 athletes, has been described as a stabilizing force in the chaotic NIL landscape. It is now being used by the NCAA to push Congress for a liability shield to prevent further antitrust lawsuits. Although several NIL reform bills have been proposed in the past, none have passed. Two current bills, the bipartisan Sports Act and the GOP-led SCORE Act, aim to balance athlete rights with regulatory uniformity while clarifying that student athletes are not employees. The SCORE Act would create revenue-based limits on athlete pay and involve multiple House committees, while the Sports Act focuses on educational support and fair market value benchmarks for NIL deals. Both would preempt state laws and address core NCAA concerns. Despite the settlement, legal uncertainty remains. Female athletes have already filed appeals challenging the deal under Title IX, and further litigation is expected. Experts note that any legislation granting an antitrust exemption, similar to the unique one held by Major League Baseball, would face judicial skepticism and political resistance. And in my column for Bloomberg Tax this week, I write a little bit about how a tax amnesty program in Illinois might provide a roadmap for the rest of the Nifty 50. Illinois' new remote seller amnesty program offers a strategic and replicable model for encouraging tax compliance among previously non-compliant businesses. By waiving penalties and interest and applying a simplified, flat 9% tax rate across the state's many local jurisdictions, the program lowers the barriers to voluntary disclosure. This approach addresses the core problem of the compliance paradox, where businesses avoid coming clean for fear of triggering audits. In contrast to fear-based enforcement, Illinois' model promotes intelligence-based compliance, exchanging amnesty for valuable insights into evasion tactics and tools. The program's design could be adapted to brick-and-mortar businesses engaged in sales suppression through tools like Zapper software. If these businesses were offered amnesty in return for disclosing how they evaded taxes, such as revealing the software they used and methods employed, states could use this intelligence to improve enforcement. Such disclosures would turn voluntary compliance into a form of strategic reconnaissance, identifying enforcement blind spots and bad actors. Illinois' policy doesn't just recoup lost revenue, it also creates opportunities to map the ecosystem of tax evasion tools and techniques. By incentivizing transparency and simplifying compliance, the initiative provides a blueprint for other states facing fiscal pressure and looking to modernize their own tax enforcement. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, we are not bound to win, but we are bound to be true.